Hey, good afternoon, everyone. In Introduction to Law, we're going to cover the chapter on contracts, which I believe is chapter 13 in your Intro to Law book. This is covered extensively and broken out in great detail in the Business Law 1 class. And if you're legal studies majors or even business majors, you'll take that class. It's an important class. I think it's important just for civic knowledge to understand when and under what circumstances you might be in a binding legal obligation, a contract, or when you're not, and the different remedies that are related there too. The book does a nice job giving you, a survey of the basic principles of what a binding contract will be, might as well, or should be, or ought to be. One of the things I always like to start off with is reminding people that not every agreement is a contract, but every contract is an agreement. The distinction is when it's a contract, there is a legal expectation to be bound. You can sue or you could be sued as a result of a breach, a failure to act according to the terms of the agreement. What's interesting about this, some people think that, well, in order for it to be a contract, it has to be in writing or it has to be for something very important. That's not true at all. If I go into a store and buy a pack of gum for $2.20, I've entered into a contract. It's completed at the moment of making the contractual agreement. I take it to the counter, I pay for it. The contract is completed at the time of the creation, all in one. It's called a sale. Um, but not every agreement is clearly a contract. So my friend, who notoriously invites me over his house on Friday and Saturday nights, stop over, we're going to have some food on the grill, and I say yes, there's no expectation to be legally bound to that. And so if I fail to go, even though he said he's going to spend money on behalf and he really wants to know if I'm going to come, because otherwise he'll lose some of the food, or the supplies he's buying will be for naught if I fail to show up, there's still not an expectation to be legally bound. And that's why every so often on these weird Morning America shows, there'll be some story where a couple were getting married and they sent out invitations to RSVP, friends and family, RSVP, but some of them don't show up. And then they get sued for the cost of the meal because there was an expectation they receive, I guess, a wedding gift, or their attendance, I guess, would be the compensation in return at a minimum. And there's always they bring in legal experts to discuss it. And it's a very clear answer. There's no legal expectation to be bound if you blow off a event that's clearly social in nature. There has to be an expectation to be legally bound. But once we're beyond that, what are the elements of a valid contract? A lot of people think it has to be in writing. That's not necessarily true. We'll go over those core type of contracts that do require a writing to be enforceable. Parties can still go forward even if they don't put it in writing. They simply aren't necessarily going to be forced to go forward or be subject to losses if they resist the enforcement of a contract. So the first thing we need, the heart and soul of contract law, is a mutual agreement, sometimes called the meeting of the minds between two or more parties. Sometimes it's also called mutual assent. What are the parties agreeing to? What's party A going to do vis-a-vis what party B has to do in order to have some kind of binding obligation flowing back and forth? That's the core of all contract is the agreement. Mutual meeting of the minds, the agreement. That's pretty straightforward. What do you need to have an agreement? Well, there has to be enough certainty. We know what the parties are agreeing to. These relate to things like usually the price, not always, but usually the price has to be clearly stated, either orally, implied, or in writing. Doesn't necessarily have to be one of the forms, just has to be clearly understood. Usually quantity, how many are you buying if it's things like a sales of goods. What's the other party's obligation? It's not always about goods. It can be about services. You're going to mow my lawn. How much am I going to pay you? When are you going to mow it? Are you going to do anything beyond mowing it? Are you going to trim the different bushes and do weeding and feeding of the lawn? All of those things usually make up part of the agreement. Oftentimes we have a combination of overt express requirements flowing back and forth between the parties that give us enough objective proof that we understand what the nature of the party's obligations are. Sometimes we can fill in the blank, like if I hire someone to mow my lawn and it's mid-June when I hire them, but we didn't put down a date of execution when the landscaper is going to actually mow the lawn, that doesn't make the contract effective. That makes it implied as to the aspect of when performance was going to be done. If it's the middle of the summer, I would expect if I made the contract today, they'd probably be out in a week or two, something like that. Same with someone painting your house. come out with a painter. They say they'll do 2 coats. They're going to charge X number of dollars. You hire them in June. You certainly expect to have the painting of an exterior of a home done within that season before it becomes too late to paint. That part of the contract would be implied. But anyways, the first element again, mutual meeting of the minds. What are the parties' obligations flowing back and forth? If there's not enough certainty that we don't know what the parties are doing between each other, then we don't have a contract because there's not enough objective clarity as to what the parties' obligations are going back and forth. They're still probably negotiating or haggling or discussing entering into a potential contract, but there's just not enough certainty going back and forth between the parties. The other is the acceptance. So one person makes or one party, I should say, makes the offer. The other party accepts. They have to accept on the same exact terms as solicited to them, or it would be a counter offer or a rejection. A counter offer does reject it. So you offer to paint my house for $2,000, 2 coats of latex paint, completed before the end of the painting season, 2023. I counter that I'll pay you $200 less, but I want the work done within 2 weeks. There's enough significance that's different in the acceptance than there is in the original offer because the monetary amount has changed, maybe not so much the time for performance. That would be considered a counteroffer. The other party is now had their offer removed from the table in light of that. They can accept my counteroffer, but they can also reject it. That's getting into the thick of the weeds of contract law. I just want to give you the essence that in order to have a mutual meeting of the minds, both parties have to agree on all the essential components and they have to be objectively understood between the parties. So a third party looking at it like a jury or a judge can know what the parties were agreeing to. The second step, or the second element in all contract law, is the parties have to have capacity and competence. Might as well deal with competency first. That's enough basic intellectual ability to understand the nature of the obligation they're entering into. Not that they actually understood it, not that they actually read it, but they could have. In presumption, it's a presumption in the law that all people over the age of 18 are competent to enter into a contract. The question becomes later on, someone might say, well, the person A had limited intelligence. They had mental limitations, either congenital or through age. They developed dementia, things of that. They didn't understand the nature of the obligation they're entering into, or they're under the influence of significant mental limitations from medicines or medications or the like. The challenger, by saying they shouldn't be in a bound legal obligation because of lack of competence, would have to bring in medical doctors or testimony from other people to show they had this kind of limitation. So when in doubt, if you're working with somebody that you think may not really have clear thinking and competency, you may wish to deal with another person on their behalf or just refrain from doing business with them because they may not necessarily be bound to enter into a valid contract. Sometimes there's issues of grave intoxication. Why would you want to risk entering into a contract with somebody who seemed to be under the influence of drugs or alcohol when there's a potential that they could repudiate the contract and not have to be bound into it? So the first element, mutual meeting of the minds. Second element, they have to be competent. It also relates to capacity. If someone is under the age of 18, this surprises a lot of people. The contract is valid, but it's subject to disaffirmance by the young person. So you sell a bicycle at a tag sale. It's in really great shape. You sell it for $500. It's a nice high-end bicycle. It's used, but it's in great shape. You sell it to that 16-year-old, and you say all sales are final. They go and take it for the next year, and they beat the living snot out of it. And they bend the frame, and the axle's broken, and there's flat tires, and they left it out in the rain. It's all rusty. Because they are under the age of 18, they lack capacity in the law. They actually have a right to now repudiate that contract, even though it's been a whole year and they've used the item and abused it and wrecked it. They have to return whatever's left, if anything, and they're entitled to get their full amount of money back. That's why those of you that have kids, and I have kids that are older now, but I always recall watching Nickelodeon all the time with my kids, and the commercials would often be geared towards kids' toys and art supply, all kinds of different things that kids would really want to get into. And what do the ads almost always say at the end? You must be 18 years old or older to call and buy this product. It's not that they didn't want to sell to children. They just knew that the children could repudiate the contract, disaffirm it, and avoid the consequence of it and get their money back. And it's a real risk for businesses. Many young people under the age of 18 have driver's license. Some of them even have money available. They go out and they can buy a car. That's a legally binding agreement upon the adult. But upon the minor up until their 18th birthday, unless they're doing it with the intent to defraud, they go out and use that car. They don't like it for a period of time, even though the sales said all sales are final, other than the lemon law or some warranties like that. That person, while still under the age of 18, can return the vehicle, get whatever money they gave 100% back. There's no discount for depreciation or anything like that. That shocks a lot of people, but that is the law. What if the minor went out and were driving recklessly and totaled the car? And let's be thankful nothing happened to the minor. They weren't injured, but the car is a complete loss. Can they still get their money back? Yes, they can return whatever's left and get their money back. It surprises people. And that's why so many businesses will not deal directly with minors. And a lot of people say, well, the business just should put up all sales are final, or there's no right of return. It's a done deal. That doesn't matter. The law trumps those contractual provisions made by the seller. And that surprised a lot. Most minors don't know it. Most parents won't help their minors get out of a contract that they validly entered into because the law does seem to be a bit draconian. But remember who we're trying to protect. We're trying to protect children from being taken advantage of by a wiser, more educated adult business owner. Usually it's a business owner, but it could be a casual sale as well. Now, there are some exceptions to the rule of minors' contracts. If a minor is contracting for what we call necessities, food, shelter, medical care, sometimes educational expenses, maybe transportation in some circumstances, maybe rent in an apartment. Those things are often deemed to be necessities, and therefore the minor does have to pay the fair market value of the services or goods supplied to them if it's a necessity. And it's a debatable thing. Nowadays, you might argue that access to a cell phone contract might be a necessity so people can communicate and function as a citizen nowadays. I don't know all this. I know food, drink, water, shelter, medical care. Those things are necessities, definitely. But then there's a gray area. Somebody might argue someday transportation might be in some circumstances. So that's the third element. The second element. First element, again, mutual meaning minds. Second element is competency and capacity, very much related concepts. Because someone who is mentally impaired, say I have dementia in and out, moments of lucidity and moments of being mentally impaired. If I enter in a contract while I'm mentally impaired, I have the ability, or somebody on my behalf, family member, my guardian, could repudiate that contract while I'm impaired. But what if I get well again through medication or just in a lucid moment, and I find out I entered into a contract and I'm conscious of it? The contract is now deemed to be ratified. And just like a minor, when they turn 18 and haven't done anything to repudiate the contract, it's ratified by aging out, if you will. Mental capacity. The next element, assent by the party, the objective standard. I went over that. I'm trying to think. The other element the book doesn't do, I don't think, nearly a greater job as I think, is there has to be a mutual exchange of consideration. So what if you're painting your barn this weekend? You're looking for friends to come out and help, and I say, I'll be out and come out and help. I'll be there Saturday morning, and the weather supposedly is nice. And I go out and I work my butt off for 8 hours and help my friend. And then at the end, I say, I hope you're paying me at least minimum wage. Well, I did it gratuitously. I did it as a volunteer. There's no obligation for the other party to pay me. Well, what if I promise to come out and help them this Saturday paint the house or the barn, and I just don't show up? Can they sue me? No, because there was no contract. We were adults. We had a mutual exchange of promises. I promised the paint. I guess you promised to supply the paint and the ladder. But you're not giving any legal obligation to the other party. There needs to be a mutual exchange of legal detriment. So it's oftentimes money in exchange for services or money in exchange for goods. Those are the classic forms of consideration. But it can be any kind of change in legal position. Like, what if I'm having a big party here at my house this weekend, and my neighbor's notorious for mowing his lawn every day? I think he does. And he's got a big, loud, commercial type mower. And I'm having my friends over. Maybe my daughter's getting married and I'm throwing it in the yard. And I want it to be a nice, quiet ceremony. Could I approach my neighbor and say, I will give you $100 if you don't mow your lawn this Saturday? Would that be a binding contract? Yeah, there's enough information to know what they have to do, not mow their lawn, use a mower engine or something like that during certain hours. And mine is to give them $100. That's called the forbearance contract. Totally legally enforceable. It's mutual agreement between the parties. We both have capacity and competency, and we're both changing our legal position. He has a right to mow his lawn this Saturday, and I have a right to pay him $100 or not pay him $100. That exchange of legal value is the consideration that comes into play. Be careful. Sometimes we think we have a right to certain things promised by another party. It's often an exchange of promises. So what if the president at Mount Wachusett Community College promised me a $10,000 bonus? If during this full year I never come in late to class, I come in on time and I keep the class for the full amount of time, and I cover the stuff I say I'm going to cover in the syllabus. I do all those things because that's what he promised me, $10,000 in exchange for doing that. The end of the year comes, I'm looking for my $10,000 bonus, and he says, hey, I'm sorry, Jim, I'm not going to be able to pay. The budget's really tight. If I tried to sue on that contract, and let's assume we wrote it down. A lot of people think it has to be right. We write it down. We have it notarized. There's all kinds of witnesses. I can't collect on that. Why? There's no consideration flowing back to the school. I already had a contractual obligation to show up on time and do the work that I outlined in my syllabus or my contract with the students. So there has to be something new flowing back and forth between the parties in terms of some legal value. And what do we call that again? We call that consideration. It's a terrible term because it sounds like being thoughtful to the other party. It's not. It's some kind of exchange of things. Now, what about this? What if my son's in college and I tell him I'll give him $500 for every A he gets, and I'll give him $250 for every B he gets. Every grade below that he gets nothing other than my admiration and hope that he improves in the future. And he comes back and he gets 3 A's and 2 B's. Do I have to pay him the money? Yes, if the contract was clear, because he has no legal obligation to do well in school and to get A's and B's. He did so in exchange. It was a negotiated benefit of the bargain, and they're entitled to it, even though it's in his best interest. There's a fine line, obviously. Sometimes contracts are unconscionable. We'll get that in a second, but so you have to have that kind of thing. And remember, offer and acceptance. If one party, what if my son says, nah, I'll do it for $1,000 for each A and $500 for each B, and I don't say anything. By him making a counteroffer, my original offer is off the table. So even if he gets those grades, I don't have to pay him because he made a counteroffer, and I didn't accept his counteroffer. So there is no contract whatsoever. The book does a nice job on it, but I think people get lost in it because, say my kid comes home and he goes, geez, I tried to up the ante with my dad and have a different contract for the degree of the different grades I got. He didn't say anything, so I'm going to try to bind him to his original offer. He can't. He didn't accept my original offer. His counteroffer killed the original offer made. That's important. That comes up a lot in business. The next element the book doesn't get into, I'll just jump ahead a little bit to it, and that is that the contract must be for a legal purpose. So it's not always about criminality. That's the easiest one. I hire someone to kill my arch enemy. I give them $10,000 and they don't do it. I can't sue them for breach of contract because the contract doesn't exist. It's an illegality. That's a straightforward one, but there's other contracts out there that don't involve criminality, but it just turns out to be illegal. I hire someone to sell my house, to find a willing, able buyer for my house for $350,000, and I promise I'll give them 5% commission on that. Turns out they're not a licensed realtor. That's an illegal contract because in order to sell and get a commission on the sale of a home, you have to be a licensed realtor in the state of Massachusetts. And it seems really inappropriate and unfair, but that's the law. If the contract is illegal, it's not enforceable, even if it doesn't involve a crime. Now, the next element I wanted to, this is a review, the book fills in a lot more of these details, is that sometimes a contract does have to be in a special form. So what are the elements again? Mutual meeting of the minds, element 1. Element 2, the parties have to be competent and have capacity. Element number 3, there has to be consideration flowing back and forth. Element 4, or at least part of the rubric, is it must be for a legal purpose. But the 5th element is sometimes it has to be in a certain form, meaning in a writing. Most contracts are not in writing, and they are fully enforceable. There is an issue of how do you prove it in court, though? Did they really say that back and forth? Did they really have this agreement? But absent, let's assume we admit everything that was said back and forth. Most contracts are oral. I just stopped at the store on the way home here from the Mount. I'm driving back. I stop at the convenience store. I never even spoke to the cashier. But when I put the food out, the salad, the grapes, the different things I put out, they ran it through the register and they told me how much money they wanted. I gave them that amount of money. I never even spoke a word. Was there a contract? Yeah, it was a contract for food or goods. And that was a fully enforceable contract. It was enforceable. We didn't need to because it was closed at the inception of at the moment, if you will. There may be warranties that go beyond that, meaning the food needs to be palatable. If it turns out to be rotten later, or there's foreign substances, I might be able to sue for breach of contract because there's an expectation that food be edible and not subject to danger. I'm getting way in advance because I don't think the book even covers that stuff about those kinds of things. But now, many students that are new to business law, I always poll students like this: how many of you think that contract has to be in writing? Over half the class, if they're really candid and honest, say, yeah, contracts, business contracts, legal contracts, of course they have to be in writing. Not true. Most contracts are not. Even very significant contracts can be enforceable against the parties just through orally. It's still express, but it's oral. Some contracts are implied. Going into the supermarket is an implied contract because we don't speak to each other. I put the goods on the counter. They tell me a price. A price comes up across the screen, or I put my card in, I pay it, it's done. That contract was entirely implied. What if I see a guy plowing snow in his driveway next door, and I can tell he's a commercial plower, and I'm knee deep in the snow, and he looks over at me, and he points at my driveway, and I give him the thumbs up. That's probably a valid contract for a reasonable cost of what it takes to plow, his reasonable charge. Can't be absorbent. Even though we didn't set a price, I would argue that there's an implied contract between the parties based upon behavior. That's where the term comes from. Actions speak louder than words. But sometimes, as students anticipate, and all of us anticipate, some contracts do have to be in writing to be enforceable. I'll use Jane Mallard, teaches law out in the Midwest, and she made a video that was pretty good through, I think, PBS, Law for Contracts or something like that, or coming to an agreement. And in that, she came up with an acronym, or she got the acronym from somebody. It's called MyLegs. These are not all the only contracts, but these are the core ones that have to be in writing. If you take the acronym MyLegs, the M is for marriage. Now, the contract of I promise to marry you and you promise to marry me, that's not enforceable law because people can break off marriages all they want. You can't force someone to go to marriage or sue them for breaking up, even without fault. There's no lawsuits available. It's called the Hart-Bob statute in Massachusetts. Most states have a similar provision. You can't sue over that. But in order to have a binding prenuptial agreement, which relates to marriage, and a postnuptial, a divorce agreement, a separation agreement, in order for those to be enforceable in law, they must be in writing and endorsed by the parties. The next one in the acronym MyLegs, this is important for business. Contracts by their very term that exceed 1 year, in order to be enforceable, have to be in writing. So if I hire you to work 3 years for $50,000 in the first year, $60,000 in the third, and $70,000 in $60,000 in the second year, and $70,000 in the third year, kind of a staged out contract, and we never reduce it to writing, but you work the 3 years, and I acknowledge I said those things for that 3 years, and you do perform the services that I hired you for, then we don't care because the contract's completed. But what if in the first year you decide to quit? Can I sue you for the second year and third year of services that you were supposed to do, and now I have to replace you at more expense, maybe with some other employee? No, I can't, because the contract by its terms was more than 1 year. You're resisting enforcement. I'm trying to enforce it, and there's a lack of writing. And by the very terms, it had to be more than 1 year. What if I hire you permanently? Does that have to be in writing? Most students say, yeah, permanently, obviously. Well, that's not true, because the job could be, or the person could die. The one party could die, both parties could die, or the work could be completed within that 1 year. We just don't know. But if the contract is for a 5-year term, an 18-month term, a 3-year term, by those very terms, it telegraphs to us that it must be more than a year to complete by its terms, and therefore it has to be in writing to be enforceable. The next one in the MyLegs scenario is land. This is important to some of you. Somebody might get into real estate as a realtor, a sales agent, a broker, or you might want to get into as a paralegal. Paralegals are very important in the area of real estate law. They do the great bulk of work, to be quite honest with you. Trained ones do, because it's very form intensive and stage intensive that the paralegals can set up throughout the process. Many times people will go look at a house and they'll love it, and they'll think it's in their budget, and they might talk orally with the different realtors. Say, yeah, we'll pay the $350,000 for that house. We really love it, but we want to put some conditions in there, like an inspection, all these different things. And the other side say, we accept the $350,000 offer. Do we have an agreement? Well, we have an agreement, but it's not enforceable yet. Why? Because it's for land. In order to have a contract for land or real estate, homes and fixtures attached to it, it has to be in writing to be enforceable. And I've been involved in a few cases like that where they initially had an oral agreement, things break down, higher offers come in from other people, sellers regret, whatever it is, and the parties never got down to reducing it to a written contract. It is not enforceable by either party against either of them because it hasn't been reduced to writing. So my legs, we got the marriage, we got the year, we've got the land. Now the E is an executor's promise. This isn't going to come up too much, but somebody dies, say my brother dies, I become the executor of his estate. If I make any promise to sell anything from my brother's estate or pay bills from my brother's estate orally, it wouldn't be enforceable against my brother's estate or me until such time as we reduce those promises to writing. I don't know why that would be that important for business law class, but it's just that part of the acronym, I guess, would be missing. Next really big one for those of us that want practical knowledge about business law, goods over $500 need to be in writing to be enforceable. So if I go to buy a bunch of lumber from a lumber yard and I go through there and I tell them my order and it's $10,000 worth of lumber, lumber is a type of good, movable, identifiable objects, and we don't reduce it to writing and I blow them off and I don't come out next week to pick it up with my semi-trailer, can they sue me for the money or the damages that they suffered as a result of me not going forward with the sale? No, they can't, because the contract was never reduced to writing for a good. Goods are movable, identifiable objects. Lumber is certainly one of them. But what if we never reduce it to writing? I give them the cash, $10,000, or I write them a check or put it on my credit card for $10,000. I pick up the lumber and I leave. Does that matter? Well, it matters in the sense that the issue of not having a writing has evaporated because the parties have executed. We're only concerned about the issue of existence or lack of existence of a written contract is when the parties are in their executory stage. They haven't yet performed on either side and one party's resisting. Parties are always free to go forward. And if they go forward, nobody cares that there was a lack of a written agreement. The next one, which relates a little bit to the executor's promise to make good on a decedent's debt or contracts, is a suretyship. Someone becomes responsible for somebody else's debt. Say I know a business and are having trouble getting some raw materials, and I want to do some contracting with them. And they go, so, geez, we can't get any more steel or aluminum in the building because we're way behind on our bills. And I contact that supplier, and I said, hey, supply them some more, steel and aluminum materials, and I'll make good on the outstanding debt if they should fail to pay it. That contract would not be enforceable upon me until we reduced it to writing. And those are the major ones. Are there others? Yeah, there's lots of others, but these are the core ones that you want to know as a citizen, as a person that functions in society. Contracts for marriage, over a year, land, executor's promise, goods over $500, and suretyships all need to be in writing to be enforceable. Are there others? Sure there are. These are the basic ones. Now I'm just going to see what else they... Yeah, we need to have definiteness, acceptance, consideration. I guess I do. Oh, you should know a little bit about third-party contracts. Usually the parties are only have the ability to enforce between party A and party B. However, sometimes party A and party B entered into contract to benefit C. Think about life insurance. Me, Jim Corman, I contact Liberty Mutual Insurance. I get a $500,000 life insurance policy to benefit my son, Clutch. Clutch is not a member of the contracting parties. He didn't make a contract with Liberty Insurance. He didn't make a contract with me. I made a contract with Liberty Insurance, but my son, Clutch, is the third-party beneficiary, and he has been identified in the contract. He now can sue for a breach. If I should die, he goes to collect the insurance policy. Liberty Mutual refuses to pay. Liberty Mutual can't raise as a defense that Clutch doesn't have any privity of contract. He's not one of the contracting party. He is a third-party beneficiary. The other ones that are more likely to come up are those kinds of things where they're assignment of rights. This happens a lot. Like a dentist might have a bunch of accounts receivable. They have a bunch of clients come in, they get their orthodontic work done there, and they get billed, and the clients pay so much through insurance, but the rest have to pay out of their own pocket. And the clients don't. And then the dentist has got all these, accounts receivable. That dentist might sell those IOUs, for lack of a better way to say it, to some third party, some collection agency. That collection agency is now assigned the rights, and they can enforce it against the third party, even though that third party, the dental client, never hired or had any relationship with that creditor that's now trying to collect their debt. Credit cards do this all the time. You might have a credit card with a certain Visa or MasterCard. You fail to pay for a little while. Next thing you know, some other credit entity is hounding you, and you're wondering, geez, what happened to Cabela or whoever you had, LL Bean credit card? Why aren't they chasing me anymore? Because they probably assigned the rights to a third party for pennies on the dollar, because it's kind of a write-off to them. And these credit chasers, or like these creditors that buy debt, often do very, very well because they can evaluate the likelihood of being able to collect that debt, and they collect usually a significant portion of it. That's what they do for a career. I know attorneys that do that. There's a collection of attorneys. They go out and they buy different kinds of IOUs, for lack of a better way of saying it, and through the power of assignment is the transfer of rights to some third party. You can become part of an entity that can enforce a contract that was never between you originally and those other parties. So in delegation of duties, this is one that's kind of interesting. I hire someone to paint my house. I know this old guy. I love old people when it comes to things like trades and skills. So I hired this old guy who I know is a great painter. I know he's really into the detail. He really gets the job done. And I meet with him and we sit down and we write up a contract, and he's going to put on 2 coats of the finest latex paint. And we're going to even articulate it's going to be Sherwin-Williams. It's going to be their best. And he's going to put on 1 coat of primer first. And he's going to do all this kind of work. And then all of a sudden, 2 weeks later, all these kids show up, these young people show up. And I say, who are you guys? He goes, oh, we got the contract from Ed. Ed sold us the contract. That's called subcontracting. When it comes to things like painting and electrical work and paving your driveway, all of those things can be subbed out unless you put in the contract that it's a non-delegable contract. People get really surprised. Well, think about it. You buy a house builder. Do you think the house builder knows every kind of, or does everything within your home? They install windows, plumbing, electrical, drywall, plaster, paint. Chances are they're going to subcontract out portions of the contract. They're responsible to make sure it ends in a workmanlike manner, or a satisfactory manner under what we call the traditional standards of the building code, housing code, painting code, all that kind of stuff. But it doesn't necessarily mean that the person you had the trust and faith in going to show up and do the contract unless you put it in a contract that it's non-delegable. Some contracts aren't delegable if they relate to a situation of a bond and trust, so you hire a psychiatrist, a plastic surgeon to do reconstructive surgery on your face based upon their reputation and their skills. You hire an attorney because they're known for their ability in court. You expect that attorney to show up and represent you in court. You expect that medical doctor that you hired. You expect your therapist to be the one that meets you for the counseling session or to prescribe the medications. Some things relate to a professional relationship. Those are non-delegable. Now, that's the person that has the duty. What about the person that's owed the duty? That's not delegable. So if you work for me at my law office, I can't send you as the paralegal or the associate attorney to go work in another law office for some other lawyer or law firm today. It'd be like you work at McDonald's and all of a sudden the boss goes, go work across the street at Burger King. You're going to work for them now. You can't delegate employment duties or agency duties without the consent of the one that's going to perform the duty. So say somebody was going to I hired someone to paint my house. Got a contract, it's all great. And they said, you know what, I'm actually going to go and do that vinyl siding, or I'm going to put on some kind of, I'm going to do stucco. I'm going to have stucco put on the side of my house. So I tell the painter, hey, don't worry, I'm still going to honor the contract, but you're going to paint some other person's house in the community. That person needs to consent to that. They're not on an obligation to do it. And if they refuse to do it, they can still sue if they have economic losses under the contract. Oh, and the other thing too, the book does a nice job. And when you're concerned about anything at all, especially if the contract has significance in terms of value or potentially important to you in making sure it's completed, write out the details. And that's what people are surprised by when they start writing down what the obligations are going back and forth. That's all of a sudden when the thing gets a little lengthy, because you start thinking of all the pitfalls. So what if this happens? What if that happens? Whose obligation is to pay this or provide that? By writing it out and creating clarity that any objective observer later on knows what your obligation is, knows what their obligation is, it avoids a lot of litigation. You should also know about contracts of adhesion. Most of us do enter into contracts of adhesion. You go to get a credit card, going back to that example. The credit card company doesn't negotiate with you pretty much on what the terms of that arrangement would be between the creditor and debtor. They give you a take it or leave it contract. That's called a contract of adhesion. You have no ability to negotiate any of the terms. They literally send it to you, and it's take it or leave it. The contract can be enforceable as long as there's no fraud, there's no trickery, there's no hidden agreements, there's no unconscionable aspect. Unconscionable means there's no provision in it that's so fundamentally unfair that it shocks the conscience. That's a binding agreement. Contracts of adhesion are very common and they are enforceable. Again, provided there's no what? Fraud, trickery, hidden obligations that aren't reasonably made known to the other party. Because if there's confusion and or doubt, the party that wrote the contract will have it read against them in a court of law. There's a presumption that will go to the non-writer of the contract, basically the contract of adhesions read against the producer of the contract. And that seems fundamentally fair as a public policy provision, I think. That's unconscionable contract and fraud in contracts. Fraud is basically, and there's passive fraud and active fraud. Passive fraud is, geez, if the other side knew that this desk would fall apart if it was moved around because it's really not built well and it's basically held together with duct tape, but I'm not going to say anything and I'm not going to lie about the desk. But boy, they probably would like to know that the thing is held together with rubber bands and duct tape and it's not going to last too long. That's passive fraud. Active fraud is you overtly lie. This desk is made out of the finest walnut in, from Europe or something, and it's actually made out of oak. That's fraud. I'm trying to induce the other party to enter the contract based upon a lie. That's what fraud is. What's a little different, but it usually has the same ramifications in contract law, is innocent misrepresentation. What if and I've met people that do that, this is a beautiful oak desk, and I'll look at it and I'll say, well, it's pine. Or this is a beautiful cherry desk, and I'm like, well, no, it's actually particle board with a sticker of cherry on top. It's a laminate. You get into all these issues. The person's not lying. They really believe it is. But that's still an innocent misrepresentation that might induce you to enter into contract. That usually, just like a minor's contract, allows the victim of either fraud or misrepresentation to repudiate the contract within a reasonable time when they realize the information is false. There's different kinds of fraud. I'm not going to get one's fraud in the inducement, which is the most common. Somebody lies to you or gives you an innocent misrepresentation about a material fact, then induces you to enter in a contract. The other is fraud in the execution. You never thought you were entering a contract. You think you're signing your kid's permission slip to go on a trip to Old Sturbridge Village for some field trip next week, but you're actually signing a contract to do a bunch of work for this other person. That's fraud in the execution. Much rarer, but it's still a type of fraud. Different defenses, pretty much straightforward. Statute of frauds. Statute of frauds is basically the requirement that some contracts of certain importance in society, we want them written down to avoid the fraudulent allegation you've entered into a contract. Hopefully remedies are coming. The remedies for the breach of contract, you sue for damages. You're not entitled to a windfall. So if I hired you to paint my house for $3,000 and you breach, you refuse to go forward, and it's still in the painting season, if I can find someone else to paint it for the same amount of money or less and do a very similar quality, and I'm not out any time or money, I have no damages. I can't sue for breach of contract because I have no loss. But what if I was only able to hire another company with a similar reputation, but it was going to cost me another $700? Well, that's my loss, $700. You're not entitled to a free contract. You're not entitled to a free painting. You're entitled to what's called compensatory damages in most circumstances. Compensatory damages are to make you whole, put you in a position you would have been in, but for the other party breaching. Liquidated damages, I'm glad it's in the book because that's usually done in real estate contracts. I agree to buy this house. I'm all excited. I put down $5,000 deposit cash. They say in the contract that if I fail to go forward and execute the contract, that my deposit will be the liquidated damages. Liquidated means it's articulated and earmarked specifically of what the other party will be awarded if I should breach. Well, what if the market's wicked hot? It was a really good deal, $350,000 for a home that could easily sell for $400,000. And for whatever reason, I get buyer's regret, or I finally found that house on the ocean that I can almost afford. And I change my mind and I back out of the contract. Well, I can't back out of the contract. I have a binding agreement. The other side could let me out, but what if they don't? And in the contract, it says the liquidated damages will be the deposit, in this case, $5,000. The law does not usually enforce liquidated damages if the other party gets a windfall, meaning that if they could just turn around and put it right back in the market and get even more money because the market's so hot, they can get $400,000, they really don't have any economic loss. And we don't want people getting windfalls from the failure of the other party to go forward to contract. So liquidated damages are often used in contracts. They're put in there what the penalty would be for the breaching party, but they're suspect. They're looked at with a jaundiced eye by the court, and they'll only be enforced if they are in the ballpark of reasonably representing what the other party suffered as a result of economic loss. You can rarely force the other party to enter contract. You hire me to be your divorce attorney. I hate doing divorce work. I haven't done, well, I just finished one recently, but I promised myself I'll never do another one, especially if there's kids involved, because they never end. And they're often, even if I think I've done a good job and really identified what the goals are of the client, I still often feel like my client often feels like they've been shortchanged in some way, not necessarily financially or legally, but just in terms of a miserable outcome because it's a miserable process, divorce court. But let's assume you hire me for a divorce. You don't give me any deposit right now. We're going to do billable hours and you're going to pay me later. I'm driving home. I stop and get a Mega Millions ticket or Powerball ticket. I win. I call you up the next day and say, guess what? I'm no longer your attorney. I'm not doing it. And you said, Jim, but you do it for $350 an hour. We have a written contract. He goes, yep, I'm breaching. You could sue me for damages. So in order for you to hire another attorney, maybe you can't seem to find another attorney with like skill and experience for $350 an hour. You only can find one for $375 an hour. You could sue me for the difference in the outcome of the costs. But could you force me? Could you go to court and say, I don't really want money from Corman. I want Corman to actually do the job I hired him for. No, because the 13th Amendment, basically the amendment that ended slavery in the country, also ended any kind of form of indentured servitude or forced labor other than in imprisoned sentences. You can't force people. That's called specific performance. You can't force people to do service contracts. But what if it was for a good? I thought I had one here. Well, this isn't a political button, but say there's a cufflink right here, this little rooster cufflink thing. If it's unique, there's not many made. Maybe this was once worn by John F. Kennedy or something, so I collect political memorabilia. And this was a unique item. I enter in a contract to buy it from you for $500. Let's assume we wrote it down because contract's over $500 for a good. It's a good. It needs to be in writing and enforceable. We wrote it. It's witnessed. Everyone agrees we wrote that down. You back out of the contract. You decide you want to keep this JFK cufflink and you want to own it and not relinquish ownership to me. I sue you. I could sue you for economic damages if maybe there's other ones out there, but I doubt it. It's a unique item. Can I sue to enforce the contract? Yes. Why? Because it's a unique item. This doesn't come up too much in most goods cases. Where it does come up a lot is real estate because there's no two pieces of real estate alike. So I have a contract to buy your home. I really like it. You get cold feet and you decide you want to keep Grandpa's home. You loved it. You have childhood memories there. You get regret. You refuse to go forward. If we have a binding contract, could I force you to actually complete the contract? Yes, I could. Kind of shocking. I don't have to, but I could is one of the choices. That's called specific performance. And now I'm just going to read some of the review questions at the end see if I miss. Oh, gifts are not enforceable. So I promised my kids I'm going to give them my coin collection next month. I said, I'm getting older. I can't see so well anymore. I'm going to give you my coin collection. Next month rolls around. I don't give it to my kids. Can they enforce that promise? No, because it's not a contract. They haven't promised to give me anything in exchange for services or goods or forbearance or anything. Gifts are not enforceable. Once a gift is completed, however, title does vest in the recipient. So assignment, delegation, fraud, in fact, talked about that. Adhesion contracts, again, those are contracts that are not what we call arm's length transaction. One side has all the power. Usually it's a big corporation or business. The other party is basically given the contract to either accept or reject. That's called a contract of adhesion. Careful, they are enforceable if done correctly, and there's no unconscionable or illegal sections or trickery, which is illegal. Advertisements are generally not contracts. So if I go and I say, oh, geez, Walmart's got a flyer out there and there's a new fry later. I don't know why I want to fry later, but air fryer, I guess they're a big deal. There's a new air fryer for $50. I'm like, wow, I thought those things cost $100. I'm going to go buy one. And they don't have any. Can I sue them for breach of contract? No, because advertisements are not considered contracts, because what if Walmart runs out of them? They might have hundreds of people throughout the nation. They run out. Maybe there's a shipment problem from wherever they're manufactured. Now all those consumers who can't pick up the advertised price would have huge class action potentially against Walmart, and all they did was simply run out of the product. Now, sometimes they have a rain check policy, but here's the point. They will still potentially be sued for false advertising if they're doing it as a bait and switch. Like they'll put a really low price on something, that's a TV that's worth clearly $500, but they say $25, for these next 3 days. All these people show up for the TVs. They say, we just wanted you to get in the store, buy some other goods, or buy the TV for $250. They couldn't be sued on breach of contract because advertising to the general public in flyers, web pages, radio advertisements, window displays, they are not enforceable as an offer and acceptance. They are an invitation for you to go and make an offer to them, believe it or not. But could they be sued in some other fashion? Yeah, consumer protection and truth in advertising and things of that nature would get those entities in trouble. But let's say, legitimately they wanted to sell air fryers at this really, really good price, and for whatever reason they run out of them. There's nothing you can do because they legitimately did not try to do trickery in their advertising, and there was not a valid offer. It was an invitation for you to basically come in and make an offer. It's a weird area. It doesn't come up that much, but it's kind of fascinating in a way. Oh, when can an offer be terminated? I agree to sell you this cup of coffee. Let's assume this is from Dunkin' Donuts or Starbucks. It's hot. It's in the cup. I bought an extra one by mistake. I come into class and I say, hey, I'll sell you this cup of coffee for $1. And I say I offer it to all 25 students in the class. I don't say anything about how long that offer is open for. How long is it open for? In that situation, is open for a reasonable period of time. If it's a hot cup of coffee, 15 minutes. They just come into class. If it's a sandwich, I offer to sell you an extra sandwich I have. I haven't touched it. It's all wrapped in cellophane, so it's protected. And I offer to sell you a sandwich, and it's a hot summer day, and the sandwich has mayonnaise on it. Hour, half hour, 10 minutes? What's reasonable? I don't know. So if that's a little different than I offer to sell you my bicycle, I don't say how long the offer is good for. You say, let me think about it. It's okay. How long does the offer stay open? It stays open for a reasonable period of time, and I don't know what that is. That's up to the finder of fact. I guess a bicycle might be a week. I think that's a reasonable period of time. Food, drink, half hour, 10 minutes, 20 minutes. But can an offeror, person making the offer, put in the offer, this is only good for an hour or for a week? Yes, then it expires at that juncture. What if I say, I offer to sell you my brand new iPhone for $500, and the offer is good for a week? Am I free to turn around 10 minutes later and say, wait a minute, what am I thinking? What am I going to do for a phone? Can I reject my offer? Yes, I can repudiate my offer. I can revoke my offer anytime prior to its acceptance. It's a very important concept. The only way around that is called an option contract. You give me $10 to promise to keep the offer open for 1 week, and I'm basically promising not to revoke it during that period of time. That's an option contract. It's a very, very powerful tool in business. Like I always used to joke in my business law class, like, all right, I'm an applicant for a teaching job at Endicott College. I don't know if there's ever been at Endicott College, but it's up on the North Shore and it's right on the ocean. And oh boy, I love the ocean. I can't wait. I want to live there. It's great. And I'm a finalist. So I start shopping for houses in Beverly, Mass, and Manchester by the Sea. What a great name for a town. So I go there and I finally find a house that's like perfect for me. It's wicked expensive. It's something I can afford. But what if I bought that house and I don't end up getting a job at Endicott College? Quite a commute to the mountain. So what do? I could enter into an option contract. I want to buy your house for X number of dollars, and I'll give you $500 as an option. So you must keep it open for me, for exclusively to me, for the next 30 days. And then when I find out I got the job at Endicott College, I could exercise the option. If I find out I don't get the job at Endicott College, I'll not go forward with the contract, but they get to keep the $500 because that's a contract within the contract. That's an option contract. It's a nice tool. And so the contract can be revoked at any time prior to acceptance unless it's an option contract. Very important to know. Bilateral, unilateral, second quote. The bilateral is what we mostly do. I promise to do something in exchange for you to promise to do something. Unilateral contract is I say, lost dog. If you find my dog, $100 reward. You don't knock on my door and say, I accept your offer. I am going to go find your dog. No, you accept the offer by performing. Contest reward systems, you run in a road race, first place is $500. That's a unilateral contract. You don't go to the promoter and say, I accept your offer, I'll be coming by to pick up the $500 after I win. No, you go and win and you get the $500. That's a unilateral, like unicycle, one-sided contract, a promise, and the only way you accept is by just performing. But most contracts are exchanges of promises and exchanges of obligations that are clearly identified either orally or in writing. That was just a kind of a very superficial review, but that's the goal of a review. It's contract law. And those of you that are paralegal majors or legal studies majors, you will get into this much deeper in Business Law 1. In fact, we spend weeks and weeks and weeks breaking out what an offer is and what an acceptance is and what consideration is. And we go through those. The next chapter, we also go through in Business Law 1, which is the different business entities that exist out there. Otherwise, went along, stay well. Any questions, don't ever be afraid to reach out. Thanks.